Hi, Ray Dickey from South Carolina CAI, Hudson Valley CAI Association Help Now. We are covering many states. This is always a very popular topic, rule breakers. And I hope we have time to get to it. You're the judge. I love that session. Everybody has a lot of fun with that. If you are here for CEUs, I am going to launch a poll. Let me launch it really quick. To fill it out, just use the question feature and say, hey, Ray, I need CEUs. But we love the commentary from the audience. Really quick, next week, if you're in South Carolina, big expo in Myrtle Beach. Huge, biggest one we've ever had. I think we have almost 400 people just for the networking party. So if you need information on that, just send me an email or use the question feature and I'll be able to get some over to you. It's going to be a huge show. Over 100 exhibitors. So I'm really looking forward to it. With that being said, let me have our panel introduce themselves with who I see first, and that is Corey.
Morning, everyone. Thank you for having me again, Ray. My name is Corey Kravitz. I'm the managing principal of Kovach, Schiffer & Nesbitt's Florida office. We're a full-service community association law firm based out of Boca Raton, Florida.
Awesome. And what's the temperature there, Corey?
It's cold today, about 55.
Oh, that is pretty cool for you. I'm surprised you're not shivering. Greg.
Good morning, everyone. Greg Girelli with Girelli Insurance Agency. We're located in Cold Spring, New York, and we are an independent insurance agency that works with community association insurance programs throughout the Hudson Valley and New York, New Jersey, Connecticut, Pennsylvania area.
And it's about minus 40 by you, right, Greg?
It's very cold, nothing is melting, and there's a lot of snow on the ground.
Okay. John.
John Legumina from the Legumina Law Firm in Westchester County, New York. We represent condominiums, co-ops, and homeowner associations throughout the Hudson Valley and New York City areas.
So Matt is new, and we made him put his, can you make your webcam up, down, left, right, mic on, speakers off? We basically ran him through the whole gamut. How you doing, Matt? Thanks for being here.
I'm good, Ray. Thank you very much. I'm Matt Heron. I'm an attorney with Herzl Law based in Farmington, Michigan. I'm licensed in Illinois and Michigan. We specialize in community association law. And as Ray indicated, this is my first time on the panel, so I'm excited to be here.
Awesome. Cynthia.
Hey, everybody. Good to see you again. Cynthia Jones with Sellers, Ayers, Dortch, and Lyons. We do community association law across North and South Carolina, anything and everything you could ever want.
Oh, excellent. O'Neill.
Morning, everyone. I'm O'Neill McCoy with Marsh McLennan Insurance Agency. We specialize in risk management and insurance for community associations, and I'm located in our sunny Myrtle Beach, South Carolina office.
Now, for those interested, O'Neill is our greeter at the expo. He's very charming. He's a huge hit at the expo. Everybody loves to meet him. So if you come to the expo, O'Neill will be there to greet you. And he may even share a funny story with you, if you ask him to. All right.
So if you're not smart, you better be charming.
Okay. Dave.
Hey, good morning, everybody. My name is Dave Byrne. I'm the chairperson of my law firm's community association practice. The law firm is Ansel, Grimm & Aaron, and we represent HOAs, condos, and co-ops in New Jersey, New York, and Pennsylvania.
All right. I want to thank everybody for being here. So rule breakers, service animals, we're going to get to them. Don't worry. I'm always inundated right in the beginning. Everybody wants to talk about service animals. We will get to them. I'm going to save them a little bit to the end. Everybody wants to talk about them. Let's just get through some of the basics really quick. Rule breakers. We're going to work today as a setup and actions, and then we're going to let the audience be the judge on some scenarios that I came up with. The first thing I think that is important with rule breakers is you want to remain educated on where you should be with the rules. Corey, what's the basics on that? How could board members and managers stay educated on this?
Great idea is when a new board comes in place, call your attorney, go through some of the rules, make sure that they correspond with the covenants and restrictions in your governing documents, and start there.
All right. John, how often do rules change? I mean, is this something if boards don't keep tabs on that they could have a rule that's basically not legal anymore, or there's a problem with it?
Yeah, they should be reviewed. If you could review it annually, that's a great idea. In practice, what I see is a lot less frequently. But yeah, like for example, you could have a rule banning uh, daycare operations, but in New York, there's case law that says you have to allow it. So that's an example.
So Matt, another one here is reasonable, proper legal language. Boards should understand that you should be using proper legal language. Sometimes the language that you guys use is a lot different than the way someone who's not a lawyer may interpret it. Do you agree with that?
Yeah, I would agree with that, but that comes out of past experiences. Often, on a language concept, one of the main things is to make sure that in Michigan, at least, you're anchoring your rules in your governing documents, your recorded restrictions. And so oftentimes rules can really only interpret or implement those recorded restrictions. And oftentimes language might go beyond that. They may use terminology that is something that exceeds the authority that's coming from their underlying documents. And that can be an issue. So it's pretty important to make sure that your words track the actual authority given to the association.
Cynthia, governing documents, governing documents, governing documents. What is, Matt touched upon it a little bit. Can you drive it home, the relationship?
Yeah, so there's a number of governing documents, right? The documents that are recorded in the public record, your declarations, your supplements, your amendments. You've got articles of incorporation that are filed usually with the Secretary of State, wherever you're incorporated. You have bylaws, which may or may not be recorded. You have rules and regs, if you're allowed to adopt rules and regs, those may or may not be recorded. You might have architectural guidelines. There's a whole host of documents you could have. It seems silly, but the initial thing I tell board members is make sure you're aware of what your governing documents are and then read them. And if you have questions, then call your attorney and ask questions.
So I think, Dave, we're going to touch upon a lot of these things as we go through different rules, but guidelines, procedures, how does this play a role in enforcing rules?
I find that it's I find that boards often have find landmines in procedures. They forget that there may have been some policy adopted years ago that said, like, no fine can be levied unless the owner is given 60 hours of notice or something. And everybody forgets all about that. And they don't follow that. And then the owner, who's the target, brings up some newsletter or some document that shows this policy was adopted, some set of minutes, and everyone's forgot all about it. So when you're doing these audits of your rules and you're reviewing things, it's very important to go back as far as you can to see if there are any of these like straggler resolutions or sort of things that are hanging out there. But I think in the end, some boards try to adopt these policies with these guidelines and these sort of time frames and procedures that they think they're like legislators or something, and all it does is create the ability of owners to find one little thing that you didn't do, and then you got to kick yourself all the way back to the starting line again.
I love going to ChatGPT and playing a lawyer now. I could put stuff in ChatGPT and tell it to give it to me in legal language, and it just sounds fantastic. And it can scare people, but I don't think that's the way to go. Does anyone on the panel believe that board members and managers should use ChatGPT for legal language? Okay. Well, Dave, I just have to state the obvious sometimes, especially if I'm joking around. Dave already touched upon this. Update. Many people on the panel, keep in touch with your attorney. Things change. That's what attorneys are for. Anybody in the panel disagree with that? Awesome. Anybody in the panel quickly have anything to add where we're at so far before we dive into these individual rules, which people love? Okay. All right, let's throw our first multiple choice out there. It's going to be, what's an acceptable exemption? So my poll system is very difficult to work. So just give me a second here. What are acceptable exemptions? Is it disability, race, religion, psychiatric, or financial? What is an acceptable exemption to a rule for someone? Is it disability, race, religion, psychiatric, or financial? You can choose multiple ones. Corey, I'm not asking you for the correct answer, but which way do you think are you surprised about the results that you're seeing?
I think it's a little bit of a trick question, but yeah, I'm a little bit surprised, but I think people are basically on the right track.
Okay, so I close these polls pretty quick. So audience, use that question feature if you want to add additional commentary, or maybe you just want to add some commentary as it is. So this one's going to be disability 89%, and then the rest of them are pretty much even, with financial being in last place. So let me start with Corey here. Corey, what do you think about those results? Why don't you start with the one that came in the most, disability? Is that an exemption?
It can be under the Fair Housing Act. Some people can, if there is a disability and they require something that doesn't, that would not otherwise comply with the rules, they can ask for a reasonable accommodation. I know you want to talk about this later, but the most common example is, emotional or, emotional support animals or service animals. But that's generally where that would come up, or disabilities, ramps, elevators or lifts, that kind of situation.
John, I have a mental disability. I need my own special entrance. I need to bring my dog through the front door instead of in and out through the side door. And it's not a service animal or anything. Or maybe another kind of, I need something special for me because I have a mental disability. How does that work? Is that I would be under psychiatric too. What's the deal with that?
Yeah, that's assuming you have a doctor's note or health provider's note to support that. Yeah, that is grounds to grant a reasonable accommodation.
Okay, so Matt, let's dive a little deeper into this. A doctor's note. This one's a tricky one for boards, right?
Yeah, I mean, there's also sort of limits on what the board can ask for, and you can seek to verify the disability and verify the connection between the disability and the accommodation being requested. But if that type of information is being verified, it's tough to really go beyond that. The other issue is if you have an obvious condition, like if you have a condition that is like plainly a disability, then the board and association's ability to ask to verify it is very limited, if not non-existent. And so doctor's notes can be tricky. Sometimes you don't want to rely on them or they seem too short, but if they contain the information required, then, they should be seriously considered.
Cynthia, I want to stay on this disability one because it's such a tricky one. I want to give you guys all an option to talk about it. Disability doctor note. What do you think, Cynthia?
Yeah, I mean, look, I hear all the time people that, like Matt said, there's very limited options and ability for the association to question the notes if they meet the requirements under the act. I have all the time, though, associations that want to dive into, well, it's not signed by the doctor, or I Googled it and they don't seem to be a real office. Those kinds of things that can just get you into a lot of trouble. So, if you've got a question about a note that's been provided, then I would say have the attorney review it and talk to your attorney about whether or not you have to grant the accommodation based on what the owner's provided to you.
So Dave, this one is going to be for boards. How far do they want to go with this? How far do they want to investigate? How much money do they want to spend? Am I right or wrong?
Yeah, I mean, because I think for the most part, the government agencies involved with this, certainly it might be more prominent depending on, what type of state ideology you have, but or even, I guess, depending on what administration is in control in Washington. But ultimately, the government people involved with this are going to tend to suggest that anything you do, other than an outright acceptance of whatever the owner wants, is likely to be a violation of the law. So, and you're going to get, and owners can file complaints for free. There's just not a lot of obstacles or impediments to getting this type of stuff into the bureaucratic system. So if you have a board that is at all leery or risk averse, you might as well just get yourself a rubber stamp.
John, I am a resident. The rule is that you must bring bikes in through the side door. I have a phobia of being attacked on the side door. I don't like the way it looks. and I get a doctor's note that I have a phobia. Is that good enough for me to bring my bike in through the front door?
Probably. You just, again, it's a reason, is it reasonable? And what's the accommodation? I mean, allowing one person to bring in a bike through the front door doesn't seem to be unduly burdensome to the association. Of course, they have to support their phobia with evidence, but as we mentioned, there's very little you can do about asking. But if that issue came up, I would certainly look at the note, because that sounds very peculiar.
Corey, you had said you thought this was a trick question.
I think at least 1, 2, 3, and 4 all kind of fall under the Fair Housing Act. If someone has, they're all kind of similar in terms of you cannot discriminate people with those conditions or those situations.
Okay. What would be an example? I'll stick with you, Corey, and then Greg and O'Neill, I'm going to go to you on which one is the most common kind of insurance claim you see. What would be an example of an exemption based on race, Corey? Can you think of one off the top of your head?
Sure. It usually comes with lease restrictions. Obviously not allowing someone of a particular race to get board approval to lease a unit in a condo.
But that wouldn't be an exemption. That would be a discrimination, correct?
That would be discrimination, yes.
I think this maybe doesn't belong in here, right? Because there wouldn't be an exemption based on race.
No.
There would be an act of discrimination theoretically based on that. Would religion fall under the same thing, Matt? Same logic? Well,
Yeah,
can I give you an example, Matt?
Yeah, well, go ahead.
Okay, thank you. I want to put a religious emblem on my gateway inside my door, right? It's part of my religion that I have to have that before I walk in, but the rules state you can't have anything on your door. What about that?
At least from my standpoint, I would look at it kind of like through the lens that Corey was just talking about from the discrimination side. If you objectively prohibit this type of thing across the board and it's not allowed, then you've got a good basis to not allow it. But if it's otherwise permitted and you're trying to say it's not allowed because it's a religious item, then they're going to back up into a problem. So I think that's it's not an accommodation issue. It's really a discrimination issue, at least as I see it.
I'm going to hit all the lawyers on this one too, because I think it's a tricky one. Cynthia, same question. Somebody wants an accommodation based on their religion. Does the association have to provide it?
Yeah, it depends. That's my great answer. I love giving that answer every time I'm on here. I've had situations where the religious practices require certain structures, like in the backyard at different times of the year. And there are rules prohibiting that. So in those instances, I have advised my clients to allow it for certain timeframes. So it's not an issue. So it doesn't become an issue of discrimination.
Dave, this one pops up all the time. Like, it's hard to think of it at the top of your head, but then when you kind of think about it for more than 60 seconds, you can think of a bunch with people having lights outside. They claim that they need their lights to celebrate their religious holiday. So they want them to extend the time frame. Commentary on that?
I think the analysis is more in line with what Matt was saying, which is that religion doesn't fall into the accommodation category. It falls into the discrimination category. If you have a rule that sets 3 different sconces that are allowed on your home, and one guy claims he needs a 4th because of his religion, the association's probably going to win. Now, if you let another guy have a 4th one because it has a political statement on it, or it has Santa Claus on it, your deviations create your evidence for unlawful discrimination. But objective rules that limit certain things, that prohibit certain things, I think are objectionable. And I don't think race, religion falls into the accommodation category. I think people think that it does oftentimes, but in my view, it's not the same thing. It's you got to have the absence of disparate treatment. If you can show objective rules are enforced the same across the board, then someone who claims to have a religious need for a different light or a different symbol on their door, they're probably going to lose. Now the government may disagree with that, but I think the law is in our favor with that.
John, I'm going to bounce over to financial, but by all means, bounce back to religion if you want something to add something. I can't pay. I can't afford it, John. I need to be exempt from this rule. I just cannot afford what you're asking me to do. Do you have to give me an exemption?
Yeah, so if you're saying I can't afford an assessment or a common charge,
Let's say I can't afford to, there's a certain rule where I cannot afford to facilitate that rule or adhere to it because it's going to cause me a financial harm. Maybe it's something with my vehicle or something like that. I have a flat tire or something and I have to get it repaired in a certain amount of time, but I can't afford it. I need to be exempt from that rule. That kind of scenario is not being able to pay for something, an excuse,
Okay.
an exemption.
I mean, it's largely no, it's not an excuse. The only thing I could think of is, so the classic example of a ramp, right? I need a ramp. And I have an obvious disability that requires the board to give me an accommodation. In New York, it used to be that one of the considerations was who pays for it, and the owner could be made to pay for it. But that's changed. So now it's just a consideration. So unless the cost of the ramp is going to break the association's budget significantly, I've been telling my clients you're probably going to have to pay for it if the owner says I can't pay for it, I can't afford it. So that's the only time I think you're going to have to make an exception.
Corey, let me throw another scenario at you. I realize I have like a million of them, which is pretty sad in a way. The association has put on a special type of deck material, and the furniture has to have a certain kind of cushioned feet to facilitate that. You can't have furniture on there that's going to damage it, right? But you can't afford to go out and buy new furniture, or you can't afford the furniture that could facilitate that kind of footing to protect this deck coating they put on. Well, I can't afford new furniture. So therefore, that rule is unfair to me. Can that be an exemption?
Fully not. Well, number one, your ability to pay is not a protected class, discrimination wise, like we were talking about before. And when you remember, your governing documents are a contract with the association, you agree that there could be assessments for certain things and you agree to pay them. And there's no room in that contract for exemptions.
A lot of people in the audience said that. They said, if you can't afford the assessment, then move. That's like a common theme here. I'm going to
I
just
think,
one more.
let me chime in real quick on that, but I think that maybe the target of the question could be more like, there's a special assessment, everyone's got to pay it by noon on Friday. Guy comes in and says, listen, my mother's sick, I have medical bills, I can't pay it. I can pay it by noon next Friday. That's an exception. Does the board have to allow for that? I think probably no, but if you tried to enforce it and the guy went in front of a judge and said, I just want an extra week, you might have an issue with getting your legal fees recovered. There could be a little drama associated with that. So while financial status wouldn't give you an exception to the rule, everyone else has to pay, it might be grounds for an exception to sort of how you pay or maybe when you pay.
Question from the audience. Matt, can we legally request written verification of a disability?
I do, so yes. And that's only though if the disability itself, if it isn't obvious. If it's not obvious, then you can ask for confirmation of it, and I would ask for it in writing and often from it doesn't have to be a doctor, but somebody who's been treating that individual and is familiar with the disability.
So Cynthia, if someone comes in with one leg and it's obvious they have one leg, the board does not need to ask them for a note, but they may need to ask someone else for a note. Is that true?
Yeah, they shouldn't be asking for a note for something that is obvious. They're not allowed to. If it's a disability that is not obvious, something like PTSD or something like that, that's requiring them to ask for the accommodation, then they can ask for documentation regarding it. But like Matt says, it's very limited what you can ask for.
Greg, disability, race, religion, psychiatric, financial. I sue the association. Which one's going to give me the biggest payout? Can't hear you. You're muted. You're muted.
Sorry.
You're
Depends on who
Yeah.
your lawyer is.
There all could be potentially a large payout. I'd probably put disability on the top of it for certainly frequency of claims at the moment. But basically, in all these instances we're talking about, you've got an unhappy unit owner, a unit owner who's unhappy with a rule, and they're going to come out and challenge it. And when they challenge that rule, everything is going to be questioned. So hopefully you seek legal advice, you are following the rule equally amongst all unit owners, and you're doing everything correct, because that's going to result in the directors and officers liability claim, where you want to know that you do have defense for these types of coverages. So you want to look into your directors and officers liability coverage and what defense and what coverage it's offering for you, because these are very common claims when the unit owner wants to get around a rule and starts challenging a rule.
O'Neill, I just got out of the psychiatric hospital. I am a protected class. I show up in my wheelchair, and I am from a unique religion, and I sue the association because they didn't give me an exception. Is that pretty much a slam dunk?
A slam dunk. Well, it goes back to what Greg said. What we've been talking about is ADA, FHA, discrimination violations, and those are typically going to fall back on the directors and officers. Discrimination side, discrimination claims tend to be the largest claims that we see on the directors and officers.
So I think the rule is here, you need to check with your attorney. You need to check with your attorney. You need to check with your attorney. Anybody on the panel disagree with that before you get involved in this? Because this is like a minefield. Does anybody disagree? Okay, and even your best intentions could get you in trouble. Federal state laws. Corey, how do they play a role, or do they? What's the pecking order?
Obviously, you have federal law absolutely plays a part, especially in terms of discrimination, Fair Housing Act, like we discussed. Obviously, your state laws, condominiums are a creature of state law. And then you have your governing documents and the priority of those documents.
Excellent. So the state has a law that covers a particular rule that we love, but the board doesn't want it. Does the board have to go through the whole process of making a rule? It's under state law. State law is over what's ever going on at the HOA anyway. So I'm going to launch the poll and we'll see what our audience comes in with on this one. Dave, how do you think our audience is going to vote on this one? Do you need to make the rule? Do you need to go through the whole process? It's a state law anyway. Why bother? Do you have to?
I think if this is state law, then you don't need to. You'd only need to do it if you want the rule if there's no law. Like how important is it to you if the law is going to change?
Wow,
like if you're happy with the law and you don't care and you let it go, but if the law were to change tomorrow, are you going to want the rule anyway? And in which case you have to adopt it.
John, 50-50 on this one. What do you think? What's your legal opinion? Or
if it's the state law, that supersedes the governing documents. You don't need to check the state law every year and then create rules to follow them. You could simply have a lot of governing documents may already have it. Like you have to conform to whatever the federal and state regulations are.
Corey, commentary on this? To add?
There are exceptions. If your governing documents were written before that law was enacted and that law was not intended to be applied retroactively, then it's possible that it may not apply and whatever's in your governing documents applies rather than the new state law.
Matt, commentary on this one?
Yeah, so I would, I think what Corey and Dave were talking about kind of tie together, and that it's sometimes good policy to provide guidance to boards. But I would give you one specific example in Michigan. Right now, there's something called a Solar Homeowners Energy Policy Act, which is a state law, but the state law itself mandates that associations must adopt a solar panel policy by April 2nd. And so there's a situation where state law applies, but not only does the state law apply, it's actually requiring that a board adopt a rule, which is a little bit of an exception to the situation we're talking about here. But awareness of it is good practice, and that's just an example of at least one state saying you must adopt this particular rule in this fashion. So it does
All right,
happen.
Cynthia, can I go to you on the next one? If you want to backtrack, by all means, do.
No, I'm good. Let's go.
All right, so this one's always a tricky one. I didn't do it as a poll. Can you make rules at a higher standard for just board members? Yes or no? Can you make rules at a higher standard for just board members?
Oh, like have a different rule apply to board members than you do everybody else?
Yeah, a lot of people like that, they can't break so many rules or they can't be elected. There's like 1,000 things in there that residents are always talking about and bringing up.
I mean, like I often see in documents that to serve on the board, you can't be delinquent or have active violations. You have to technically be a member in good standing is how it's defined. I think you can do things like that if they're written into your governing documents and they apply to who is running for the board. But just a general rule in the community to apply differently to board members than owners, no, I don't think you should be doing that. The rules are going to apply across the board to everybody.
So a lot of people are saying board members should not have separate rules, but we should be held to a higher standard. And a lot of managers are also commenting. Does anybody disagree with that on the panel?
Well,
Excellent.
I mean, they are held to a higher standard with their fiduciary duties that they have as board members. And so, but that just exists as in their capacity as a member of the board of directors.
Okay. And they're not allowed to get away with anything extra. That's for sure. So they don't have to have different rules, but they can't get away with anything that another person would not. True? Anybody disagree?
Well, that's going to get them into trouble every time if that's what they're doing.
All right. So we have a rule breaker. Alert, alert. We have a rule breaker. So let's talk about what action should be taken. So I'm going to throw a multiple choice out there. How should you document this issue? You have a rule breaker. I'm going to launch the poll. Should you take photos? Is that acceptable? Should you interview neighbors immediately about this issue? As a board member or manager, should you start interviewing people? Should you take photos of the inside of their home? Maybe you could take it through the windows, or maybe you could peek around the corner. I don't know. Should you watch them closely? Is the manager allowed to dedicate their resources to watching this one particular resident to make sure they're not breaking the rule? Or is it none of the above? Or is it none of the above? So once again, this one is coming in strong for photos of the exterior good, interviewing neighbors maybe, and then photos and watching closely, spying is pretty far behind. Dave, I want to jump right to the spying one because I think that one's interesting. Is a manager allowed to dedicate their time and resources out of their day to watch one particular resident who has been reported as breaking a rule? Or is that going too far?
I mean, like, I don't see that there's necessarily a problem with a manager working to see if a guy's breaking a rule. If the board wants to pay a management company for that service, I guess it would seem kind of silly. I don't know why anybody would do that, but there's maybe a particular situation that comes up. I've had managers spend significant amounts of time during a day or a week, gathering information or watching certain things. And if there's a particular dispute or a litigation going on, sure.
I love scenarios. Corey knows that I love them. All right. So the manager gets a report that Bob is letting his dog poop all over the place. So the manager knows that Bob goes out between the hours 11 to 12 to walk his dog. Can the manager scope out just for Bob, just waiting for Bob to see if they can catch Bob in the act? Or is that unfair to Bob?
I don't think it's unfair at all. Bob has no right to break the rules. It's a public area, and if the manager is sitting there in a golf cart just waiting for Bob to break the rule, then there's nothing wrong with that.
John, commentary on that?
Yeah, I agree. There's no right to privacy in the common areas also, and I agree with Corey.
So Matt, manager can just wait for Bob?
In the situation you gave, I would say that would be okay. I would think the conduct of the board though, and the property manager acting on behalf of the board does need to be reasonable though. And so there is each example is kind of important to know what's the fact scenario. In the example you gave, it seems reasonable. He's going to be out here at a certain point in time, and so I'm going to check it out, and I'm going to figure out if he's really doing it. But if they stake the house out 24/7 or something like that, I think that would be a much different scenario and would touch upon that unreasonableness that could get a board in trouble.
Cynthia, would this be an example of unreasonableness? Bob is running for the board. There's not been a complaint about his dog pooping, but one of the board members tells the manager to keep an eye on Bob, get out there between 11 and 12. Is that something that could get anybody in trouble for?
Yeah, I mean, look, if we're treating Bob differently than we treat anyone else, that's going to be a problem. If they're getting complaints and they're investigating the complaints, great. That's what managers are supposed to do. But as long as they're investigating them against everybody and not just against Bob, I'm okay with it.
Corey, is this going to fall into the same parameters for interviewing neighbors?
I think the only reason to interview neighbors is if there is a complaint, and neighbors, if neighbors are eyewitnesses, you need to document what they saw. And if you're ever going to prosecute something, they may need to be witnesses to provide testimony for any kind of enforcement action if there's no other evidence.
Does everyone agree that taking photos of someone's exterior as far as a rule breaker is acceptable? I mean, that's a pretty obvious one, right? Okay, so this leaves us one with the interior. This comes up all the time. John, I'll start with you. You could see the inside of someone's unit. They are breaking the rules in there. They have a dog that they're not supposed to have. And you could see it through the window. So you're the manager, you take a picture of it. Are you allowed to do that and use that against the owner?
In New York, I wouldn't do that. There is an expectation of privacy inside. Pointing your camera inside a unit is probably a violation of the right to privacy in New York. So I would not do that in New York.
Interesting. Dave, New Jersey, can I take a picture inside somebody's unit?
Yeah, you can, except you can't take pictures of the areas that are like, I forget what the specific language is, sort of like clothed in, intimate setting type thing, or some vague sort of language that most people think that means bathrooms and bedrooms.
Oh, interesting. So New York, no. New Jersey, kind of. Corey.
Yeah, it's okay in Florida, to the extent that, if there's a dog in the window, you can take a picture of that. Often we'll have neighbors fighting and they're putting their own security cameras in the windows facing at each other. And you can obviously see that, right next to the glass. But it would be a little bit awkward and potentially violating some criminal stalking statutes if you're zeroed in on the window, especially in someone's bedroom, like Dave mentioned.
Cynthia, by all means backtrack, but how about if I have a zoom camera? I zoom in through the living room and I zoom into the kitchen, which is in the back of the house, but I got a great camera. I can see everything. Is that acceptable, not acceptable? And how does that play in your state?
Oh man, no, no. They've got an expectation of privacy in their private property, and no, I wouldn't be okay with that. It's one thing if it's a camera on the outside and picking up things, but zooming in through windows to get to different parts of the property, no.
How about if the dog's just at the front of the window? Like dogs like to watch what's going on, right? So you can clearly see it. Would that be acceptable?
Yeah, I don't, like, if I'm walking down the sidewalk on the public street and I can see the dog in the window and I snap a picture of it, fine. If I'm starting to go onto their property to get up close to the window to take a picture, then I've got other issues, including possible trespass to be concerned about. So if I'm on a public area and I can see it, fine, I can snap a picture. Any farther than that onto their property or into their property is very concerning.
Yeah, well, I'm talking about the street. I'm not even talking about like going on the property. Matt.
So I guess the only thing I'd really add to this is I would probably ask for permission to access the house because, you know, a board in Michigan does have, a condo at least, has the right to conduct a reasonable investigation, and a community member, an owner, it would be a violation of the bylaws for them to refuse access if there's a reasonable expectation of a violation going on. So I'd actually ask to go in and then document it that way. And if they refuse access, then pursue a bylaw violation for refusing access in the first place.
I got to tell you, Matt, if the board or manager came to my house and basically wanted to come in my house to inspect it for a rule violation, I don't break any rules. I think I would tell them to get lost.
Yeah.
I don't think there's any chance of hell of me letting them in. But you're saying, and that is an option for boards and managers to ask. And that, could it be used against them that the owner says no?
Yeah, it can, but there needs to be a reasonable, you know, basis to go in. Like think about a pipe, you know, a pipe's burst, and you want to investigate the pipe.
Okay.
You know, you need access to get in there, but that extends to, you know, a justified and reasonable expectation of another violation going on. It's really an extension of the same concept.
Okay, I just want to be clear because we've done entire sessions, like if the pipe's breaking and it's causing damage to the building, we all know that you can gain access to it, right? Or you think there's a fire or anything, but I was just talking about rule breakers. So anything to add to that? I'm going to go to the rest of the panel on this one very quickly because it's very interesting. Corey, very quick commentary.
Well, I get shot in Florida if you knock on the door looking to investigate a rule violation in Florida.
John.
Yeah, I mean, we don't, yeah, New York is a little different, but you know, New York has probably, it sounds like tougher right to privacy right laws. So yeah, don't open up that can of worms. Giving the owner, a disgruntled owner, a chance to not only sue you, but probably go right to human rights to get a free shot at the board.
Dave.
The general rule for me is access is about sort of property damage, you know, preventing property damage, dealing with property damage, and, you know, maybe safety, rule violations, you know, the wrong color, you know, whether you have whether your floors are covered in a stacked unit, whether your floors are covered, might not really come within that. So I don't know that my clients would be allowed to demand and force entry through, you know, locksmiths and those kinds of things to investigate whether there's been a rule violation. But property damage related concerns certainly would be allowed.
Just to be clear, the question was just asking for permission. No.
Well, yeah, but if you can't tell a guy you're doing it anyway, I mean, you can ask anybody anything. I mean, that's like a stupid, kind of a silly question. You can always ask someone to do something. They could just be like, no. So that really doesn't really matter.
Cynthia.
Yeah, I mean, can you ask? Sure. Can they say no? Sure. Except apparently in Michigan, which is amazing to me. But, you know, you learn something new every day.
It's funny how people think of things. I had a board member here who I like very much, but they were under the impression that because they had a key to my unit, that they could enter my unit at any time for any reason because I had given them the key. And I explained to them that is absolutely not the case why they have a key of mine. And there's no way they could just enter my unit for any reason whatsoever. So people have, you know, they do look at things differently. This is why we need lawyers. Matt, this is a yes or no. Other owners have the right to read incident reports of other rule breakers.
Well, I mean, it's a corporate record on one hand, and so, you know, they could request it. But if there's a reason to redact it, there are privacy concerns to take into account, and there is a basis to limit access to corporate records for certain privacy reasons, at least under Michigan's Nonprofit Act. So it'd be a maybe. I mean, it's a probably yes, but there may be circumstances to limit it if the board chooses to limit it into privacy.
All right, very quickly, Corey.
In Florida, it's an official record of the association that can be inspected per unit owner requests. But again, if there is any kind of sensitive information, that can be redacted.
John.
Yeah, New York's the same. It's gotten to the point where owners are entitled to see just about anything. The exception being if there's confidential information.
Dave.
I agree. I think once it's in writing, it's a corporate record. I'll say also that, and we've talked about this in other streams. There may be limits to what an owner can see simply by requesting it, but in the event of litigation, those types of things are definitely subject to subpoena. There's no way you could hide them. But personal information, bank account, social security number, phone numbers, you could redact that. But in the event of an actual dispute with somebody or about something, that those documents would, in my view, be absolutely subject to production.
Cynthia.
Yeah, those are not records that are required to be turned over in North and South Carolina, so I wouldn't turn them over absent litigation and a subpoena.
Okay.
Interesting.
Yeah, it's always interesting from state to state. Owners have the right to a warning first. I'm going to launch this one. I'm going to do it really, really quick, audience. And as you guys are answering, I know it kind of plays on the poll here a little bit. Corey, really quick, do owners have a right to a warning first? They're breaking the rule. Do you have to give them a warning?
Generally, no, unless your governing documents provide otherwise.
Okay. John, the audience is saying 69% said yes. How about New York?
Yeah, I'm gonna agree with the audience. Even if your governing documents don't mention it, in almost every case, a court's gonna want to see that you gave warning. Frankly, if you could give more than one warning, it'll help you a lot. Courts do not like even looking at these type of cases, so you want to show them that like you gave plenty of warning, and the board had no choice but to do what they did.
Boy, Matt, state to state, it varies a lot. What about you? Owners have a right to a warning first.
Not necessarily a warning. I mean, the documents are spelling out the way things are supposed to go, but in a condo, they'd be entitled to a hearing. So you can't, if you're going to hold them in default, especially if you're going to impose a fine, you've got to give them an opportunity to respond at a hearing, if you're going to do a fine in a condo in Michigan.
Cynthia, the audience is saying, but the published rule is warning enough. What are they, children?
Yeah, I mean, the question is, do they have a right to a warning? And I'm with Corey, unless their documents require you to give a warning first, you don't have a right to a warning. But I also agree with John. Is it a good idea to give them a warning? Probably yes.
Okay. If you give one person a warning, no, do you have to give it to everybody though, Cynthia?
You treat everybody the same.
Oh boy.
Consistency.
All right. And the audience is all over the place on this one, but for the most part, they don't want to give warnings. They're basically saying you're a grown up, you can read, you know the rules, you break the rules, you're going to have a problem. Let's do warnings. We just did that. A warning may be public, like a sticker put on the door. Let's fly through these really, really quick. Dave, can you stick a sticker on somebody's door for everybody to see because you're a rule? This person's a rule breaker.
You're going to laugh at this, but I mean, it might depend on whether the sticker can come off. I mean, like, I don't know. It would really depend on what the stickers say. This guy's an ass. He doesn't comply with the rules, or does it just like, it would depend on what the point of it was, what it looked like, whether it would damage the door, and all kinds of crazy questions you'd have to ask.
All right, let me make this a broad one, Cynthia. Do boards and managers have to be careful not to embarrass someone if they're a rule breaker? We talk about this with fines. I'll let you run with it from there. I think you know what I'm trying to get to here.
Yeah, I mean, publicizing somebody in the community who might be breaking a rule is not something I want my clients to do, just like publicizing delinquencies. Those are private matters between the owner and the association. You do not handle it publicly.
So Matt, is a big sticker of dog poop put on someone's front door because they're a pooper violator, is that acceptable?
It's not necessarily a violation, but what Cynthia is getting to is probably not good practice. I mean, the praise in public and criticize in private really holds true if you want to be able to maintain sort of civility and good harmony within the community, even as to people in violation.
All right, Corey, quickly, please.
Florida, we have statutory shame walks where the whole community lines up on the sidewalks and the person who broke the violation walks down the street and everyone yells shame, shame. It's a state law.
You make me nervous because I'm always afraid I'm going to edit that in as a short, and that's not true, right?
It's obviously not true.
Okay, you make me nervous because I got to edit these things, and sometimes I'm tired. I'm editing them at like midnight. Okay, John, anything to add to that?
Yeah, no scarlet letters in New York.
Okay.
You open yourself up to libel lawsuit.
And Greg and O'Neill, I'm sorry that we're not getting to a lot of insurance. I'm going to have you guys definitely do the closing thoughts. There's just so many more rules here. I'm just trying to get to. And I
You
want
know,
to
and
get
Ray, in New Jersey, owners have an absolute right to see the delinquency list, to see all the financial records, to see people's names, their addresses, what they owe. That's might be different from whether you affirmatively publish the information, especially when a lot of times the information is wrong. But owners have a right, an absolute right to inspect it and see
I got to
it.
state that because it's a whole other topic we've done about that, about delinquencies and whether you can shame people or not, or what you have to give them. Really quick, I got to do this one quick because I want to do at least one of the judges. You're the judge. Corey, hearings, are they entitled to a hearing? I don't agree with you. I think I didn't break the rule. Do I get a hearing?
In Florida, if a fine is being levied by the board, then a hearing before the board is required by statute and usually by the governing documents also. But that's only if a fine is being levied. If you're just enforcing, if you send to my office for someone to move a car or seek a court order for something, then there's no hearing before the board required.
Okay, John.
Yeah, I think in New York, it's pretty much the same. A court will read into, before you fine, your constitutional due process rights. Now, I know that's a federal right, but there's also state constitutional rights. And I've done plenty of fining cases, and the judges almost always want to see that you warned. And if they find out that the board refused to have a hearing, and the owner asked for a hearing, that's also problematic.
Matt, hearing. You have
The
to give it to him.
condo, yeah, kind of what Corey was getting at. In Michigan, if you're in a condo and you want to impose a fine, you need to hold a hearing before you can impose that fine. The hearing's not necessarily required by statute for an HOA in a non-condo setting, but the document's almost always.
Cynthia.
In North Carolina, if you're fining or suspending services or privileges, you're required to have a hearing. In South Carolina, you're only required to have a hearing if your governing documents require you to do it.
Okay, what a pain in the neck. Dave.
In New Jersey, we have a mandate, but I wouldn't call it necessarily a hearing. We call it alternative dispute resolution. ADR, and that's mandatory. It is not necessarily a prerequisite to fining or punishing, but the courts have ruled that if you begin to take action and an owner asks for it, then the court automatically has to dismiss your action without prejudice. But the ADR can come in any form you want. It's not a quote unquote hearing, which a lot of people hear that word and they think it's like Law and Order, some kind of trial. Well, what I'm talking about is like, maybe you get into a room together and it's not with the board, it's with some independent person and you try to talk it out, you hug it out a little bit.
Okay, do me a favor, Cynthia, just kind of think about what we spoke about real quick. I realize I don't have a South Carolina attorney on here, so maybe you could just make some clarifications for us at the end, okay? If you can, I'd appreciate that. I apologize for not noticing that before. Let's do really quick non-fines, things that you can or cannot take away from people. I think this is going to be, it depends. Maybe you could ban someone from the pool at gym. Maybe you can't take away the parking. Maybe you can, maybe you can't ban them from an annual meeting. You're going to have to check with your attorney on this. Anyone on the panel agree that these things vary greatly on what you can and can take away from people? Can I leave that as it is?
Yes.
Okay, excellent. Service animals, really quick. Corey, this one's kind of a simple one in a way, right? First of all, if something's a service animal and it's classified as a service animal, meaning that it provides an exact service that could be documented, by all means, there's nothing you can do about that, right? It can go anywhere or do anything, correct?
Yes and no. Service animals are not considered pets, so you have to look at it through that lens. But if the owner of the service animal is still, and the service animal is still, pooping on the grass and not being picked up, you don't get a free get out of jail card, for those types of things.
Right. Your service animal can't run amok. It can't bite people. It can't bark all night. It can't poop all over the place. It's still expected to follow the same rules. It's just going to be allowed to have access to basically wherever it needs to go with that individual. Is that pretty close?
You did a great job there, Ray.
Okay. Now we get into the gray area, the emotional support area. Now, Dave, we got to make this quick because we're running out of time. All right. Emotional support animals. Are we just going to give up, throw our hands up and say, yep, everybody can have one now?
My view is that, like I said before, if you are a board that is risk averse and you don't want any insurance claims and you don't want legal fees and you don't want drama, then yeah, you've got a stamp. You just get a approved stamp out and approve them. If you're not going to fight, you might as well just approve it, because ultimately, when they file a complaint with the government will most likely believe you violated something, and you'll be off and running with some big dramatic conflict. So if you know ahead of time you're not going to want that, you ought to just stamp approved and be done with it. And then if any owner complains, how come there's a sheep in this guy's backyard? Your answer is going to be saying he gave me a doctor's note. Call Congress, call the governor. Not my problem. I mean, that's how I tell clients. The first thing is, are you risk averse or are you willing to take risks?
Cynthia, I can see what Dave's right. I meant, ugh.
Yeah, I mean, I think the only exception to that is if the animal is posing a danger to person or property, then I think you could exclude it. But other than that, I mean, yeah, there's very few restrictions with regards to the emotional support animals. We know that well in North Carolina.
So, Matt, unless the dog's pooping, barking, breaking rules, and running amok, if it's an emotional support animal, you're basically stuck.
Well, if they've been able to demonstrate a disability and a connection between that disability and the need for the animal, they've kind of laid out their claim. Assuming that they've been able to verify the disability and the need for the animal.
John and Dave, stop me if I'm wrong here, but what I heard Dave say, hey, maybe you could fight it if you really want to go to the mat. You want to spend $1 million on this thing, and you may lose anyway, whether you deserve it or not. Is that where we're at with emotional support animals, John? Somebody's close to having an excuse, they're going to get it.
You're not going to spend $1 million, I hope, but yeah. So there's an exception. I agree with everything everyone's been saying about emotional support dogs, but there's an exception. And then actually in New York, they're starting to crack down a little bit on people faking it. So if you think there's a suspicious request for an accommodation, you have the right to ask additional questions and maybe even warn the asker that if you're doing this fraudulently, you could be penalized.
Okay.
So yeah, there is an exception.
Corey.
I agree with John. Florida has a very similar crackdown statute for fraudulent reasonable accommodation requests.
Okay. I'm going to do you're the judge's overtime for whatever. I'm hoping at least one of the attorneys can stay and do it for those who want to do that. So, and I'm going to put it out there as shorts and clips and things like that. Let's do closing thoughts very quickly. We got about 1.5 minutes here. Greg, I'm sorry. Thanks for being a sport today. Insurance aspects of this, closing thoughts.
It's been an excellent seminar with great advice from the attorneys. I mean, the closing thoughts are you have rules and you're trying to live in a community and you want to enforce those rules. When someone's going and breaking the rule, they know they're breaking the rule. And what they're looking to do if they get caught breaking the rule, and obviously they're usually hoping not to get caught, but if they're breaking the rule, is make it about something else. So when you're enforcing the rules, make sure you're taking your attorney's advice and your professional's advice and giving your the best defense to why you made the actions you made against the rule that was being broken. And don't give them a discrimination claim or some easy out to make this about something else.
O'Neill, Greg took a lot of your thunder there, which is great. He knows what he's talking about, but go ahead.
No, great. I think I have 2 closing thoughts. One, make sure you have a really good attorney, because I think this is wonderful advice that we heard. Second off, I think going back to the very first question about governing documents and the importance of those, I think a lot of claims from a directors and officers standpoint can be mitigated by having a full understanding of the governing documents, because the number one directors and officers claim is failure to adhere to the governing documents. So if boards understand the documents thoroughly.
All right, let's do closing thoughts super quickly. Corey.
Check with your attorney before starting enforcement, because some boards will pass rules and regulations that may not conform with the authority that's given with them in their declaration, and it could get them into a lot of trouble.
John.
Yeah, so when you enforce your rules and regulations, try to be reasonable and try to be realistic. You don't want to create more problems than you had before you started to enforce the rule.
Dave.
I'll reiterate the point I made about risk. A client of mine, we took an emotional support animal case all the way through a trial and then all the way up to the New Jersey Supreme Court. The only reason the board did it is because the insurance company paid for it, everything, including the experts.
Cynthia.
Yeah, I agree. Be reasonable in what you're enacting with your rules. Be consistent in your enforcement. And if you have questions, ask your attorney.
Matt.
All of the advice that's been given. I mean, there's been, everything that everybody just said is take it to heart, and that's what I would reiterate.
All right, awesome. I want to thank, don't jump off, lawyers, yet. I want to thank everybody for being here. We are going to go to do the judges. It should take about 10 minutes. They are a lot of fun, so I'm going to see if I could keep at least one of the attorneys here to get through that, but I'll take them all. With that being said, I want to thank everybody for being here. If you can't stay, if not, this will be out there and it'll be the recording out there. So thanks everybody for much appreciated. And we dive deep in a lot of these things also. So today we just went.
Thanks, Ray.
Okay, thank you. All right, attorneys. If you got to go, you got to go. Dave, can you stay?
I can stay, yeah.
Cynthia, if you got to go, you got to go. I know you got a tight schedule.
Yeah, no, I got a few more minutes. I'm good.
Matt?
I'm good.
Okay. Corey, John?
I'll stay.
Okay. All right. And I don't know who's still there for the audience or not, but let's get to it. These are really interesting cases. They are not easy at all. And let me go to the poll here. And I'm not actually going to rush through them since I'll be able to pre-record these and edit them out. This is case one, called the sign case. Just imagine the background music like on LA Law or something like that. I don't know.
Ding, ding.
I like it, Dave. I like that. You make a lot of background noise, and I'm glad that it's actually coming.
No one else watches Law and Order but me, probably, so no one knew that reference.
Okay.
But I went to law school.
All right. The case is signed. The association has reasonable rules about political signs and windows, including the size. Okay. And there's Bob, and he's got his little sign over here. You see in the window? But Bob put his supersized sign 2 feet back in the room. Look what Bob did. He's a rule breaker. These are all hard cases about rule breakers. He bought a giant sign. He put it 2 feet back. But the rule says you can only have a small sign. Everyone else has this. But Bob has this. But it's 2 feet back from his window. So you're the judge, audience. Are you going to rule for the board member? Are you going to rule for the association? Because the association said, Bob, you can't do this. You can't do it. Or are you going to rule for the owner, saying, tough luck, association. Bob outsmarted you. So let me find that one here for me. And I'm going to launch the poll. And don't say anything, audience, yet. And let's see what our audience comes through with here. If they're still here, I haven't even checked. Okay, I'm going to give the audience time. I think this was a real one that I did find. I changed the circumstances around a little bit. All right, I'm going to end the poll. And I could tell you before I end it that it's about 50-50 for the most part. And I think that's interesting. So I'm going to share the results right there. All right, I'm going to start with Dave on this one. Dave, is the association, you're the judge. The audience,
is the sign, yeah, but I need a little more evidence. Is
No.
the sign, board
No.
members, is the sign like an internal election, or is it like for a regular election? Like for
no, there's no more
president?
evidence. You have to either pass or rule on the information I give you, because no one wants to be here for 3 hours with the lawyer question.
The case dismissed. I mean, I don't have evidence.
Okay.
I can't rule on it.
Cynthia, being a sport and playing along, because Dave is known for these questions.
In New Jersey, it depends what the content is. Like I'd have to refuse the rule.
We all know that.
I'm saying that the rule was no signs in the window. This is not a sign in the window. Owner
You can
wins.
have a sign in the window. The rule was you can have a sign in the window, but there was a size restriction.
Yeah.
But Bob took a sign and put it 2 feet. It's not in the window. It's in his house.
Not in the window.
And
Not
it's
a
you.
violation. Very technical reading of the rule.
So Bob gets away with it. And look, audience, the lawyers are not giving you exact rulings here. Like Dave said, there's 1,000 different things that would really take place. We're just having a little bit of fun here and doing a little bit of food for thought. Matt, what do you think?
I mean, I'm tending towards the board. I mean, I understand the not in the window argument, but and even though it's political, I'm siding with the board.
Yeah, and by the way, audience, the lawyers are going to vary on this because I'm not giving them all the information they need to actually, we'd be here for 5 hours if it was a real court case. John.
I'm going to rule in favor of the owner. I'm going to assume that the window rule doesn't specify if it needs to be in the actual window or 2 feet, and then with the advice to the board that they need to rewrite their rule to make it clear that you can't have a big sign not only at the window but within X feet of the window, or wording like that.
Corey.
To go with the board, I would argue that the plain meaning of the rule suggests that it cannot be. It's for viewing through a window. The relation between 2 feet or within the window frame is not important.
Interesting. Now, Dave, I'm going to give you a chance to be a sport and play along. Do you want to do that, or do you want to ask lawyer questions? What do you think?
This isn't real, right?
Okay. All right. No, it's not a real case. I don't know Bob.
All right, then I can play along.
Thank you. What is your ruling for the board, or it's been split? What do you think? Does Bob win,
Board.
or does the board?
Board.
The board wins. Okay, that was an interesting one. You guys really were all over the place. All right, here's the next one. I think there's 3. You're the judge. The condo has rules about not decorating hallway doors, but some do. That's okay. I mean, people do it here. I'm a rule follower, but they do it. Maybe you have a welcome sign. Hey, welcome. How you doing? But Bob said everyone has theirs, so he did his. But Bob did, you jiggle. If you jiggle, you should wiggle in. And you really can't see. If you jiggle, you should wiggle in. And the board said, look, that's ridiculous. You're breaking the rule. You can't have that. That's an unreasonable sign. So let's go to the audience about the jiggle wiggle case, and let's see if they feel, and these have real meaning in reality to a lot of similar situations. This may be easier. So audience, are you ruling for the owner, or are you ruling for the board? Okay, I'm going to end this one really quick. Wow, about 50-50 again. Surprised it's not overwhelmingly one way or the other. 54-46. I'm going to close this one. I am not starting with Dave first. Don't worry, audience. We're going to let him eat his peanuts or whatever he's eating over there. He loves peanuts. And he makes a mess, by the way. Have you ever seen his office? There's peanut shells all over the place. It's like an elephant is in there. Okay. That being said, Corey, are you going to rule for Bob? Can he keep his jiggle and wiggle sign? Or are you going to say, no, Bob, you can't have it?
Say no, Bob. The board, I believe, would win again, even in a situation where they've failed to enforce the sign restriction, where they may have waived that ability to enforce it. There's still a nuisance provisions in the governing documents, pretty much all governing documents, and I would argue that this is a nuisance, regardless of whether it's a sign on the door.
Okay. John.
Yeah, I'm gonna say the same thing. I think the failure to enforce other signs is problematic, but I think those can be distinguished from this sign. And yeah, almost every place has a nuisance rule.
Matt, I think people do this on purpose just to start trouble. But go ahead. What do you think?
I mean, I agree with Corey and John. I mean, I think the board, for reasons other than the sign provision, it's likely going to be successful. Either the nuisance or annoyance provision. Nuisance might be kind of tough, but there are usually annoyance language there's usually annoyance language that goes with it that would seem to suggest the board should win.
Cynthia, I am surprised by your answer so far. Seriously, I thought,
Well,
I-
then
go
I
ahead.
might really surprise you with this one.
Go ahead.
This is fun. Okay, so in North Carolina, no, I think that if the board has allowed other people to decorate their doors, they have waived the right to enforce the rule. And then Bob can decorate his door. And also in North Carolina, the courts have said they're not enforcing general nuisance provisions either. So I think Bob wins again.
I agree with you, Cynthia. Dave, I would tell Bob he has to get rid of his sign and just send a notice to the community that everyone has to remove all their stuff off their doors.
I think that the first answers are like from Corey and John and stuff. I think were correct, except Cynthia's point probably applies to most of what I deal with in New Jersey, where if the owner is able to demonstrate a pattern of discriminatory enforcement of the rule, it's going to be a real problem for the board. Certainly, it's going to be a problem for the board to recover its attorney fees, which then means the board will think it lost, even if it wins. It's a real problem.
Okay. I'm going to end with this one. There's a lot more I have here. We'll do it another time, but this one is actually, I think, going to be easy, but it may be shocking for the audience. So I'm going to do it. I almost hate bringing it up because it's a pretty hot topic that can upset a lot of people. Let me just line this up here in my thing here. You're the judge, audience. Bob has been using the ladies' locker room. Bob has been using the ladies' locker room. There's Bob. Nobody wants, I don't want to see Bob in the locker room, and I'm a guy. He's in the ladies' room. They're not happy. And the board is telling Bob, you can't use the ladies' locker room anymore. This one is pretty simple case here. So I'm going to launch a poll. Can the board tell Bob that he can't use the ladies' locker room? And it is coming in strong that the board can. 95% overwhelmingly saying, yeah, the board could tell Bob you cannot use that locker room. So I'm going to end this. I'm going to share the results. I know I moved quickly, and I'm going to go ahead and close it. All right. I am going to start with Corey on this one. Corey, I hear about this all the time.
This is easy in Florida. The board would win and Bob would probably go to jail.
John.
I don't know about jail, but I think the board would win in New York also. The boards, they're private, all right? So, they're allowed to enforce reasonable rules, and not having men in women's bathroom is probably going to be upheld as a reasonable rule.
I'm surprised by that in New York. Okay, Matt.
I do think the board would win. I would just point out that in Michigan, our civil rights laws have been amended to prohibit discrimination based on gender identity. And so that's just one thing, not that this is in play here necessarily, because I don't think it would apply, but that has been, the Elliott Larson Civil Rights Act includes that.
So I did the question wrong. That's why you guys are lawyers. I should have said that Bob identified, this is old. This is about 5 years old, right? So I should have said, Cynthia, that Bob identified as a female. Would have that changed this case?
I mean, it would in Matt's case, right? I mean, he just said they can't have a rule that discriminates according to his state law. So I think the answer to that just depends on the state. But yeah, I mean, the question as it was it's common area. Board gets to make the rules on common area.
All right, I'll leave it with you, Dave.
I focus most of my practice in New Jersey. We have some, certainly we're the anti-Florida when it comes to this stuff. So I would have to take a little bit of time to read what we call the law against discrimination. That's what we call it. And there's a lot of stuff in there about this kind of thing. And I'd have to really put some in-depth analysis into it. We've got local ordinances too with this kind of stuff. It's hard, it's rough.
I would say in New Jersey, there's a chance, Dave, I'm not putting you on the spot, where Bob would be allowed to use the ladies' room and there'd be nothing the association could do about it.
Yeah, I don't know. If Bob wanted to actually go public and claim he was a woman, maybe he might have some traction. But
yeah.
But,
All right, well-
it could be a problem. It would certainly be in the newspaper. New Jersey could be a legal problem for the association, but I'd have to research it. A lot would go into it. I don't know. We haven't faced this yet, thank God.
I had so many other cool ones. Maybe I'll have you guys back. We'll do them as with an audience. I had someone, Bob, with skulls. Bob of course, I had poop. You know, everybody's got to have poop. If you're a judge, you got to deal with poop stuff. I had scooter ones. We used to do this just as an entire session. I had religious ones. But I want to thank you guys for staying. I want to thank the audience for staying so much and letting me get to this. Cynthia, could you just stay back for 1 second? I want to insert some stuff about South Carolina if I didn't get to it, if you don't mind. I know, Cynthia, if you have another 5 minutes, if you don't, I understand.
I have about 5 minutes.
Okay, I'm going to let everybody else go. Thank you so much for being here. And I'm
Bye,
going to go
everyone.
right to Cynthia.
Okay,
As soon as they
thanks.
sign off, Cynthia, I'm
Bye.
Bye,
sorry.
everybody.
Cynthia, we didn't have a South Carolina attorney with us you are a South Carolina attorney, I apologize. We didn't have someone who I designated as a South Carolina attorney for this live stream. I was hoping you could add some additional commentary in regard to today's live stream if you remember and you feel warranted.
Sure, yeah, in South Carolina, things are very different. So there is very few statutory restrictions and regulations with regards to planned communities. There are some with regards to condominiums, which South Carolina fancily calls horizontal property regimes. But what it comes down to in South Carolina is basically the board can do what the governing documents allow the board to do, and that's it. They're not really given additional authority to make rules, to impose fines, to enforce violations in the statutes. It just doesn't exist yet down there. So the basic rule is what's in your documents controls. Make sure you're following those documents.
Thank you, Cynthia. Thanks for staying.
Thank
And
you.
I do appreciate you staying, Cynthia, and I'll let you get back to doing some billable hours.